Good afternoon. Good afternoon. How can I avoid probate court? What is probate court? Should I avoid it? What are the benefits? What are the detriments? What are you talking about, Tina? Today you'll learn about how you can avoid probate court, but let's define probate court first of all. So my name is Attorney Patterson. I'm a licensed attorney here in the state of Michigan. Every state has probate court, and that is a specific branch of the court system, right? With judges, lawyers, all that, that will deal with property distribution upon death. So when you die, what's going to happen to the house? What's going to happen to the cars? All that stuff. Probate court has authority to hear that. And they also deal with disabilities and minors. So when it comes to um, an elderly person who may no longer be able to care for themselves, the probate court can hear that. When it comes to minors who may have some kind of disability issues, the probate court can hear that. So in essence, the probate court is a very specialized section of the court system that will deal with death and disability. Just kind of remember that. That's the general overview of what it is. Okay. So how can you avoid it? The reason a lot of people want to avoid probate court is because, number one, the court process itself is public. That means that whatever you put on file, the public can access it because the court is a public institution. Okay, it doesn't matter if it's Supreme Court, the probate court, your local county court, they're all public, right? We pay for it out of our tax dollars, so the public has the right to access the information. So a lot of people want to avoid probate court because they don't want their business to be out there in the public, right? And then also, I mean, anytime you go to court, it can be a hassle, not only in terms of time and money, but just the process itself can be very complex. Even a lot of lawyers that I know who are not familiar with probate court, they may get asked to do something that has to do with it, and they have no idea what they're doing. Their stuff gets rejected, it gets sent back, and a lot of times they have to ask me, like, what did I do wrong? Because it can just be a tit for tat, and that can be very, very much a hassle, especially if it's not something you're used to dealing with. Okay, so those are some of the reasons why you really want to avoid it. Um, if you want to, if you don't mind it, or if there may be times when it becomes essential. For me, the only time when court is essential is when you have an opposing party who will not budge. They will not do anything else. They just want to be contentious. They want to be adversarial. They want to fight. That's the time when it has to go to court because somebody else will have the authority to decide. All right. I always tell my clients first, never go to court first. Always go to court last. Okay. Just because there are so many different alternatives you can use that don't take up the time, don't take up the energy, don't take up the money, the confusion that court can cause. All right. And the relationships. Once you get into court, whoever's on the other side of you, whether it be friend, family, business, partner, whomever, it can get nasty, right? Because there's conflict. And depending on how far it goes, it may get stretched out so far that it never comes back together. All right. So there are reasons why you will want to avoid it. If those are some things you want to avoid. But again, this is life. Sometimes people are people. They're going to be difficult. It's going to be difficult. And court may be the only way to see it through. All right. So with that being said, let's talk about how you can avoid it. So let's say, all right, Tina, I have a house and I have all this money or I have all this property. I don't want anybody to know I have this stuff. I'd rather just kind of pass it along quietly and make sure that, it goes to who I want it to go to, or it is used for the purposes I want to use it for. Well, okay, great. Then let's bypass probate with these tools. All right. And at the end, we're going to get to one tool that's very common when we're talking about probate and death, but it doesn't avoid probate. That means probate court has to hear it. All right. So let's talk about how to avoid it. Number one is with a trust. You may have heard this, and trust me, right? On this channel, we're going to be talking a lot more about trust because it's becoming a lot more popular. I'm getting a lot more calls about it. People are really interested in it, but kind of they don't know what to do or where to start. So let's just talk about, this is a basic overview. Okay. I do have resources that go into depth a lot more. You can check them out in the link in the description of this video. All right. So a trust is essentially a document that will allow you to put assets into it. So a house, money, bank accounts, policies, okay, clothing, valuable artwork, jewelry. And if you put it into this document, it will avoid probate court. All right. The biggest benefit is that it's private. So that means that it does not have to go through the public court process. You don't have to list out the inventory of what you own. So you don't need to list out house and how much it costs. You don't need to list out cars and how much they cost. You have to do that with probate court. But with the trust, you don't have to do that. Okay, so a big advantage is that it provides privacy. Think of it as your own private bank account. Okay, you have a bank account. I have a bank account, right? You might have several. Only you know what's in it. You manage it, right? Maybe you have somebody else help you with it. You have beneficiaries, right? Hopefully you do, because we'll get into that. Please do, all right? So if something were to happen to you, whatever's in that bank account, let's say you have $100,000 in that bank account. All right, you manage it, you use it for your purposes, use it for whatever you want to use it for while you're alive, which you can also do with the trust. But once you pass away, then if you name a beneficiary on it, they have access to it. Similar thing with a trust. All right. So think of it like that: your own private account, whatever you put in there, and then you can name a beneficiary to give it to afterwards. With the trust, there are three main roles you need: a settlor or a grantor, trustee, and again beneficiary. Okay. So the settlor / grantee, or excuse me, grantor, you might hear that. That's just the person that creates the trust. All right. So if it's yourself, it's you. Trustee, the person that manages the trust. If it's yourself, it's you. You always make sure you name somebody else to take over after you. You might hear it be named as a successor trustee. So let's say it's going to be spouse or brother, sister, mother, whomever it is. It could even be a professional person, okay? But the point is they're going to be managing what's in there. So they're going to manage the money, or they're going to manage the property. And they manage it for the benefit of the beneficiary, right? Whoever is supposed to benefit from whatever's in the trust. That's a very basic overview. Again, not to be too complicated and get into the weeds, but that's just how it works. It will provide privacy. You need those three different people. Okay, so let's think about this. It'll privacy, people, last P, we'll do the three Ps: privacy, people, purposes. Okay, trust has to have a particular purpose. It expires when there's no more reason for it. Okay, and then trusts are very fascinating. They're very diverse. They can last for a very long time, but it all depends on what you want. Your purpose, right? Your purpose for the trust. How do you want to use it? Do you want to just use it to bypass probate court and give everything to the kids when you're gone, or do you want to use it to fund a charity, or do you want to use it for grandkids? You want to keep it open longer? I mean, there's many different ways to use it. It's a very diverse tool, a very flexible asset. One other thing I just want to mention with that, when it comes to purposes, there are two, even though there are many different purposes, there are two basic types of trust to provide these purposes. One is revocable. You might hear that. Often it's called a revocable grantor trust. Second is irrevocable. And as the name sounds, okay, revocable, you can discharge it, you can terminate it, you can close it, you can do whatever you want to do with it, change it, everything. Irrevocable, you cannot. All right. Irrevocable serves a very specific purpose. Okay. It can house assets that you are not responsible for. So if you were to have some kind of major creditors or some kind of major something coming after you, they couldn't go after those assets. Okay. And it can also be used generationally. All right. Very specific purpose. It's beyond the scope of what I want to talk about now, but I do just want to let you know and be aware of that. Okay. Because those are the two main types that you'll see, no matter what the purpose is: revocable, irrevocable. Can you change it? Can you not change it? All right. So trust, that's the first tool you can use to avoid probate court. Why? Privacy, right? You need those three people, many different purposes, and just remember those two types. All right. The second tool you can use to avoid probate court is when it comes to you actually still being alive. All right. A trust you do create and you can benefit from while you are alive. And obviously it still continues after you pass away, just depending on the purpose. How long it will continue will vary. All right. But powers of attorney, that's the second one. These are very, very, very critical tools, and they are only good while you are still alive. Okay. They help to look after you. All right. The oh goodness, why am I blanking? You name an agent under it. Okay. But you are the person who can designate somebody to serve as your power of attorney. There are two specific types. One is for your money and like your business purposes. You often hear that called a durable or a financial power of attorney. The second is healthcare power of attorney, and that's someone you can name to administer healthcare treatment. Whether you want to be on life preservation, things of that nature. Okay, so just two different types to keep in mind: healthcare, finances. Think of it like that. All right, these are key because, again, they give the direction of your health and your financial affairs to someone you can trust to carry out your wishes in the event that you become unable to handle it yourself. And the reason why this avoids probate is because otherwise, you would have to go through probate court to get the probate court alternatives, which are a guardian. You have to go through a guardianship process for your healthcare affairs, or you have to get a conservator by going through a conservatorship process for your financial affairs. When I say you don't want to do this, I mean it wholeheartedly. You don't want to do this, okay? Having powers of attorney in place before anything happens to you can absolutely eliminate this need, okay? The processes for guardianships and conservatorships are so much more paperwork, number one, especially when it comes to conservatorships, because you have to list out all the assets. Sometimes you have to go through mountains of bank accounts, of statements, and all this stuff. And you have to provide an accounting for it. I mean, it's so much work. It's so much work that sometimes we lawyers don't want to do it, right? Because it doesn't need to be done. What I've seen most of the time, it doesn't need to be done. A simple power of attorney can eliminate all of that paperwork, all of that time, all of that money, all of that hassle, all that effort. I mean, power of attorneys, you get it done and all that is eliminated. Okay. And again, they're so effective because it's a very simple process, very, very valuable though, because they can be used again throughout your lifetime. All right. You want to make sure that you're updating it, and that if you need to change someone who is no longer alive, right, that you may have named as your power of attorney, your agent, or if you need to, kind of reevaluate relationships and say, I'm not sure if I want you to serve anymore, or if that person themselves becomes unable to serve because maybe they've had their own accident or something's happened in their life where they're no longer up to a standard, right? They don't have the capacity to serve anymore, then you can change it, okay? But the point of it is for it to last past your disability. Okay, so if something were to happen to you, you were in an accident, maybe you cannot physically move the way you need to anymore, your power of attorney can help you. Okay, maybe it's some kind of mental cognition. You see this often with elderly people, as they go into older age. Mental illnesses start coming in, not illnesses, but mental cognitive functions decrease, and then you'll see things like Alzheimer's, dementia. Those are very common. But if you've had a power of attorney already executed before that and it's still valid, then you can still use it and you'll still be able to have somebody look after your own affairs when you're not able to. Powers of attorney also expire at death, so there's no need to go to probate court. All right, and I'm going to have a caveat about all of this at the end, but it avoids the what can be tumultuous guardianship and conservatorship proceedings. I've seen it, not even in my own cases, in cases in court. It's so it's definitely not private. Again, everything is out in public. So if you ever have any issues, that's going to be out for the public record, number one. But number two, there's a very big loss of control there that as like a free thinking and independent spirit, it's just it breaks my heart to see it a lot of times. It really does, because these are people, right, who are still talking, walking, maybe older, may have some kind of issues, but really clearly don't want this court process happening. And it's not that it's forced on them, but it's because there's nothing else that can be done at this point. The court has to get involved. Somebody has to step up and take care to help them. They have to go through this process. And so you just really hate to see it. Whereas, if they were in their, we call it right mind, meaning if they had the mental capacity, if they had this power of attorney already in place before any of that happened, then all of that would be out of court. Okay. So that's a big one when it comes to avoiding the probate court. And let's see here. I don't want to take up too much time. We might have to do a part 2 on this. I'm going to give you one more, then maybe we'll come back with a second part. Okay. and then we'll do our caveat. So we talked about trusts, we talked about powers of attorney. This is a big one, our last one today, beneficiary designations. Okay, I mentioned like how a trust is like a bank account, and on bank accounts you can have somebody called your beneficiary. If you name them, they can take over the money in the bank account, and it bypasses probate court right away. They get the money immediately. Okay, beneficiary designations are so important and so critical. It doesn't even matter if, I won't say it doesn't matter if, okay, but you want to make sure you have a name on there, because if not, then that money will go into probate court. Excuse me, it'll become part of the estate. And depending on how, your plans are set up, it can become public record. Okay. You want to name an individual to take over the funds in that account. You can name a trust too. Just be careful, seek professional advice, because there are some accounts such as not life insurance per se, but retirement accounts especially, where individuals must take over. There's very, very, very specific rules on that. All right, so seek a professional. I don't want to get too much into that now to confuse anybody. Just be careful. All right, but you can always name an individual to take over the account. It bypasses the probate court process. Okay, it's very important because I've seen I don't like to share like my war stories, right? But let me tell you, I've seen significant amounts of money sitting in a bank account that could not be released because there was no beneficiary designation. Okay. Nobody was on the account. So we had to open up a probate court process. We had to get a probate, the estate's bank account name, get the estate a bank account. What could have been done in a matter of days took months because there was nobody else there to take over. All right. But the important thing here is just to realize that this is a tool you can use to stay out of probate court. And with bank accounts, life insurance policies, retirement accounts, those are like automatic pretty much, because they're a third party contract. Okay. So the court really has nothing to do with it. It's a contract between you, your bank, you, your life insurance company, you, and the retirement the HR kind of retirement process in your company, whomever it is, however you have it set up. Those are the rules that will take over and they will govern. And let me tell you though, be careful. Make sure you review these designations, because again, that's the contract you sign with that entity. The court has nothing to do with it pretty much. Okay. I've seen recently, maybe I'll do a whole nother video about this. This happens so much more often than you realize. Okay. But there was a gentleman, this was a man who had a lot of money. He had about $750,000, so $750,000 in an account. I believe it was a retirement account. And he had an individual named on that account. He had that same individual for like 40 years, so he's never changed it since the 80s. And this was an ex-girlfriend. Okay, man finally passes away for whatever reason. Never got around to changing that name. Guess who's getting the money? It's ex-girlfriend. Okay. Now his estate, right? The people who have opened up something in his name, they are fighting against it, and I believe it's his brother. But the court is essentially saying no, because this is the contract between you and the retirement company, whoever administers it, right? The court really there's nothing the court can do on that. The hands are tied. The contract is there, and you've had opportunity to revise it, and you did not do it. So, been broke up for 40 years, but she's getting a $750,000 windfall. Okay. That can happen. So make sure you review those beneficiary designations. Don't leave them empty, and always review them. My rule of thumb, not even every year, I would say every quarter, make sure you're just updating it, make sure it still looks good. Okay. So those are the 3 ways that you can bypass the probate court process. This is my caveat though. They're not foolproof. Not everything in life is foolproof. So again, let's just go with this beneficiary designation, the last one I mentioned, with the ex-girlfriend battling brother, right? Now, brother as representative of the estate, and the estate is just, who is able to take care of the person's property after they pass away. You open up an estate for them and they act on that behalf, okay? They're going to court to try to stop it. So the probate court will always have authority to hear some kind of dispute, even if it's in a trust. Let's say this was a trust, and the beneficiary didn't like how the money was being administered. They can always go to probate court and try to have it changed according to the rules, right? But it's a lot harder to do that because the trust is so much more solid, right? There's so much more detail in it. There's so much more intention in the execution of it that it's like, well, how can you really battle against it, right? So that's a protection. Even though the probate court does have authority to hear those disputes, there are built-in protections just in that way. Okay, so powers of attorney, same thing. They're good. They can last. They can be valid as long as they're validly done. But the dispute might come if somebody like was forced to do it against their will, or we call that duress or coercion. Somebody was forced to do it, bribed to do it, something of that nature. But again, you have to provide the proof that happened. Okay, you can't just be like, oh, I don't like it, so I'm going to challenge it. Well, how much is that worth to you? Because it's going to add up. Okay. And finally, again, with the beneficiary designations, yes, you can also have that be disputed in probate court. They have the authority to do it. But you see how these layers of protection kind of tie the court's hands. There's not a lot they can do unless there was some kind of clear wrongdoing. Okay, so I just want to let you know that there is still some authority there. But overall, these are some of the best ways that you can use to avoid the probate court process. All right, so I hope this was helpful for you. We'll be back again next Thursday, July 25th at 1:30 p.m. Eastern Standard Time. And if you want more information and a lot more detail, you can't wait until then. We do have some more information available for you in the links in the description. Okay, so you can click on that and find out. All right, until then, take care.